The Supreme Court is hearing a case about Mississippi's 15-week abortion limit. The court is considering the question whether all pre-viability prohibitions on elective abortions are unconstitutional. In other words, this case asks how late or early can a state protect a baby from abortion. CMP's Undercover videos make this case simple. If a baby is old enough to be trafficked for body parts, he or she should be old enough to be protected from abortion by a state law. The unborn babies Mississippi is trying to protect with its law are the same age as those most at risk of being trafficked for organ harvesting and experiments. High-level Planned Parenthood leaders caught on CMP's undercover footage consistently admitted that babies older than 15 weeks were needed for body parts harvesting.
For example, so I had 8 cases yesterday, and I knew exactly what we needed, and I kind of looked at the list, and I said, all right, this 17-weeker has 8 lambs, and this. So I knew which were the cases that were probably more likely to yield what we needed, and I made my decisions according to that too. So it's worth having a huddle at the beginning of the day.
Sometimes poor Heather would be there saying, oh, I really need liver today.
Yes.
I would be a 17-week patient who would be perfect.
And look at the experiments funded by Dr. Fauci's NIAID office. This series of invoices from Baby Body Parts Company, Advanced Bioscience Resources, to the NIAID shows the body parts sold to implant into lab mice for NIAID's Humanized Mice project. In every invoice, the body parts are from babies aborted at 17 weeks or older, sometimes as old as 22 weeks. In another experiment funded by NIAID, where the scalps of aborted babies were stitched onto lab rats to keep the baby's hair growing on the rodents, the scalps came from aborted babies aged 18 to 22 weeks. To make matters worse, the burden of having abortions and yielding aborted babies for experiments disproportionately falls on minority communities. Abortion itself has a huge racial disparity. Black women make up only 13% of the female population nationwide, but account for 28 to 34% of abortions. And when it comes to harvesting baby body parts from abortions, Black and brown women are specifically targeted by some research labs. The Good Map Project for harvesting fetal kidneys at the University of Pittsburgh set explicit racial quotas for body parts. Even though the metropolitan area supplying the abortions is 80% white and less than 13% Black, Good Map sought only half of the aborted babies to come from white women and half to come from minorities, with a full 25% to come from Black women. Planned Parenthood was happy to apply racist quotas for aborted baby parts during CMP's undercover investigation, too, if it made selling the body parts more convenient. Even though the clinic intake forms already identified patients of genetic interest, Planned Parenthood Gulf Coast suggested harvesting from all Black women at the clinic to make things easier.
So there's another potential client who is working on sickle cell anemia. The prevalence of the carrier gene among the African American population is like 1 in 12. So if you have 12 patients, you have 12 termination patients of African American descent, during the week, and that means statistically at least one of them is likely to be a carrier, so at least one of those fetuses will have will be appropriate for inclusion. It might just be a matter of if there's 12, if there's
collect African American, and you're going to have your controls. You're going to just by numbers.
Abortion past 15 weeks clearly commodifies human beings and perpetuates some of the worst social injustices. That should be reason enough for states to do everything they can to limit it, and that shouldn't be controversial. The laws of 38 states across the country and the U.S. Federal Code already recognize unborn children as persons under the law, with extensive legal and constitutional protections from violence and other injuries. There's just this one crazy exception for abortion. And the 14th Amendment clearly authorizes and obligates the federal and state governments to protect living infants in the womb. And its equal protection rules forbid arbitrary exceptions, like disregarding babies targeted by abortion or pre-viability age. The same state lawmakers who ratified the 14th Amendment also passed laws protecting babies in the womb from abortion. Dr. Martin Luther King Jr. said,
"Injustice anywhere is a threat to justice everywhere.
Allowing pre-viability babies to be treated unequally and killed by abortion has led to tragic and lethal consequences for viable age babies. In 2013, Dr. Kermit Gosnell was convicted of multiple counts of murder of viable age babies. Dr. Gosnell delivered babies alive in his abortion clinic and killed them by snipping their necks with surgical scissors. Gosnell got away with these murders of born-alive babies who could have survived for years. How? The grand jury that indicted him found that even though illegal activity was reported at his clinic for years, it was never investigated because the government believed that would interfere with Gosnell's pre-viability abortions. The state's disregard for pre-viability infants' lives directly enabled and covered up for Dr. Gosnell's attacks on post-viability infants. The same thing happened with criminality at Planned Parenthood. Planned Parenthood tried to leverage their privileged status as a provider of pre-viability abortions to prevent scrutiny of their baby body parts businesses in Texas and Southern California. It was only after CMP's undercover videos were released that state investigations found violations of medical standards and ethics at Planned Parenthood Gulf Coast and terminated their state funding. And prosecutors in Southern California secured a guilty plea from Planned Parenthood's baby parts company in Orange County. Old abortion cases like Roe v. Wade and Planned Parenthood v. Casey are outdated and just don't make sense anymore. We can't look to old 1900s era political cases for guidance here. We have to follow the Constitution and the rule of law. It's not unconstitutional for a state to limit some pre-viability elective abortions. In fact, there are many good constitutional reasons to do so. The Supreme Court has to uphold Mississippi's law.